The Washington State Bar Association. I hope we're on record. Rex, are we good to go? Good. Is the phone on? Fantastic. Welcome back again. We're continuing our session from yesterday. We want to move as quickly as possible so we can get to our guests who all very dutifully came yesterday, and they very kindly came back again today. We don't want to get out of their time. So the first thing on our matter today is actually myself, Rajiv Majumdar, the president, on matter of executive committee matters. I'm going to streamline discussions a little differently today. Oh, I'm on the big screen. Is there any public comment on this issue of executive committee matters and proposed revisions to the charter? 1, 2, 3. Hearing none, I'm going to move to the governors. I guess I could talk about it a little bit. We just reformatted the charter to better reflect what the executive committee actually does and integrate the Committee for Mission Performance Review criteria that used to be in the Committee for Mission Performance Review charter, which no longer exists, and updated the Executive Committee charter. Are there any questions from the governors on this matter? Hearing none, I would entertain motions to tell me to jump off a bridge or to pass the revised Executive Committee charter.
So moved.
Which one?
I hear a motion and a second. And I know we have Governor Hunter on the phone. Is that correct? Okay, on her way. Fantastic. So, all in favor? Aye. All opposed? Very good. The motion passes. Now we'll move to our next agenda item, which is Legislative Committee Matters, and I will turn the meeting, or look to Governor Cicchetti on these matters.
Thank you. As I mentioned yesterday, the Legislative Review Committee has met twice this year, and we have another meeting that's planned for next week. We've worked with the Business Law Section Corporate Act Revision Committee, where we have two guests will be presenting today on two different bills. We have one more that we anticipate discussing next week, somewhat related to entity regulation. We might have to come back at our next meeting and complete that one for the legislative session. And then I hope online we have Sanjay, who will be discussing our legislative priorities. But to start off, I'll be introducing John Reed from Davis Wright Tremaine and Diane Lourdes Dick from Seattle University. Is that correct? So if you could come to the presenting table. And as I mentioned, we do have two bills. I will defer to our guests, and they can explain the two bills and what they do and what they hope to achieve in the legislature. Thank you.
Thanks very much. I'm John Reed, and I want to say a few words about who we are, where we come from. Diane is a law professor at Seattle University School of Law. She teaches and she's published extensively in the areas, among others, of corporate law and corporate bankruptcy, corporate taxation, and mergers and acquisitions. And she's a member of numerous bar associations, most notably for our purposes, the Washington State Bar Association, and she's been an active member of the WSBA, serving on numerous corporate law-related, business law-related committees. Again, notably, for purposes of this discussion, the Corporate Act Revision Committee, which you'll hear me refer to from time to time as CARC. I'm a corporate lawyer. I've been with Davis Wright Tremaine for over 40 years. I've been involved in bar association committee activity with the business law section for almost that same period of time. I've been on the Corporate Act Revision Committee for close to 25 years and served as its chair for over 10 years, more or less. Diane and I are going to divide the presentation into two. As you mentioned, there are really two sections that we're talking about. Diane's going to take the lead on our board diversity, gender diversity proposal, and I'm going to take the lead on the more rather mundane changes that we're proposing that are more extensive, but they're changes that are resulting from our charge, which is to retain our corporate act, RCW 23B, as for the most part a model act based upon the ABA's revised Model Business Corporation Act, which it revised fairly extensively in 2016. Given our lack of person power, we're not in a position to be able to, completely review and decide which changes we want to adopt all at one time, so we're taking it on a methodical basis, and this year we're dealing with one chapter, and presumably we'll do another chapter or two next year. I'd also like to say a word about our mission. Corporate Act Revision Committee has been active, maybe one of the most active legislative committees since its inception in 1975, just a couple of years before I started practicing law. And its mission has been to continuously consider and review, as I said, changes by the ABA with regard to its model act upon which we're largely based, as well as considering changes that are necessitated from changes in corporate and securities law generally, changes to other important commercial law states, corporate laws, so that we can assure that we have a competitive corporate law that will encourage Washington businesses located in Washington to incorporate in Washington rather than to flee to usually Delaware. And this is something that we think is really important because Washington practitioners know Washington law better than they know other states' laws. Having a competitive state act will keep them from dabbling in other states' laws where they're more likely to get in trouble. Their clients are more likely to be less well served. And so that has been our charge. 23B is an integrated, I think, wonderful statute, but I'm a 23B nerd. But it's integrated in the sense that it's a little bit like the UCC. Everything kind of relates to everything else. So we have jealously guarded the statute in the last 40 years from interference. That is, legislators who decide that they want to do something that is their pet project to the Corporate Act, and whether or not there's a policy that's a good policy, we have fended off many such attempts, and when we think we can't fend it off, we have tried to embrace it but take charge of it to make sure that when the changes are made, they meet the purposes, the underlying purposes of the state act. And that's not just making sure that when you change X, you've also considered Y, Z, and all the other letters elsewhere in 23B that might be adversely affected, but also to make sure that it meets our overall purposes, which is that the state act is, like the model act, is what we call an enabling act. It generally sets out a few requirements to be a corporation, but then it has a whole panoply of options of things that the corporate planners, the organizers, the boards can decide whether they want to take this option or that option, and then we provide for remedies or for what happens if we choose this option or what happens if we ignore that option. And so we are reluctant about adopting a statute that has a mandate with penalties associated with it, because that's just not the way the act works. And we want the act to work simply and understandably for Washington practitioners. As I said earlier, it minimizes the traps for the unwary. It minimizes the risk of legal challenges. Another important consideration is minimizing burdens on and costs from the Secretary of State's office. We work closely with the Secretary of State's office to make sure that no change that we make, that the changes that we make can be properly overseen administratively by the state. And of course, as I said earlier, it's really important for us to maintain a statute that is competitive so that we don't have people fleeing to Delaware, which is not something that would be good. Now, with all that background in mind, I'm going to turn the floor over to Diane, who's going to take the lead on discussing the gender diversity proposal.
Thank you. First, thank you so much for the opportunity to come and speak with you today. As you may know, last year the California legislature passed a rather pioneering law, making California the first state to require corporate boards of directors to include women. The statute passed in California requires publicly traded corporations headquartered in California to include at least one woman on their boards by the end of this year, as part of an effort to close the gender gap in business. By the end of July 2021, a minimum of 2 women must sit on boards with 5 members, and there must be at least 3 women on boards with 6 or more members. Now, companies that fail to comply face fines of $100,000 for the first violation and $300,000 for the second or subsequent violations. In January 2019, a group of Washington state senators proposed legislation substantially similar to the California statute, except that, unlike the California law, the Washington version would not apply to foreign corporations. It would, however, apply to private corporations. In the meantime, there have been quite a few other similar proposals introduced and adopted all around the country. In August 2019, Illinois passed a law urging public companies to have, depending on their size, 1 to 3 women board members within 3 years. The adopted version of the law was a compromise to an originally introduced legislation which would have mandated that boards include women and would have imposed monetary fines similar to what was done in California. Meanwhile, other states such as Massachusetts, Pennsylvania, and Colorado have also passed non-binding resolutions encouraging increased board diversity. But while states have marched forward with these legislative proposals, the California statute has faced or generated quite a bit of controversy. Business groups there have questioned the legality of a state imposing such requirements on corporations, many of which are incorporated in other states. And most stakeholders acknowledge that the law has some serious flaws. Indeed, the law is already facing a test of its legality. In August, the conservative legal group Judicial Watch filed a lawsuit in California State Court on behalf of taxpayers, arguing that the law violates the California Constitution. The group is asking the court to block the Secretary of State from spending taxpayer dollars and using taxpayer-financed resources to enforce the measure. So in light of these developments, those of us on CARC have spent quite a bit of time thinking about how best to address this important issue, the important issue of board gender diversity, while also providing a solution that's consistent with the overall spirit of the Washington Business Corporation Act. We believe that amending the WBCA to include a provision similar to the earlier proposed legislation, something that's based on the California law, would be counter to the enabling nature of the WBCA. It would cause impacted Washington corporations to migrate to other states for incorporation, and in view of the potential litigation risks, could diminish the ability of Washington legal practitioners to provide clear advice on Washington corporate law. An enactment of that sort would also render it difficult for Washington lawyers to advise boards and shareholders of private, closely held Washington companies who may be unable to comply with the quotas. Just as troubling, such a provision would make it difficult for Washington lawyers to be certain when advising Washington corporations regarding the validity of any corporate action taken by a board that failed to meet the requirements. To this end, CARC leaders have met multiple times with the Senate Working Group to develop and refine a proposal that would be consistent with the enabling nature of the WBCA, that would also minimize the risks of litigation while helping to foster high standards of competence among Washington legal practitioners. So unlike the California statute and the previously introduced Washington legislation, our proposed board gender diversity provision does not include hard quotas or monetary penalties for noncompliance. Instead, the proposed provision is modeled on the sort of comply or explain framework that's been successfully used by the SEC and in various other countries, including Canada and the UK. Our proposed board gender diversity statute operates as follows. Beginning no later than January 1st, 2022, at least 25% of the directors on certain Washington public company boards must be women. If a public company does not have a gender-diverse board, then it must provide, either in its corporate website or its proxy materials distributed to shareholders, a board diversity discussion and analysis describing its approach to developing and maintaining diversity on its board. Private companies and certain public companies would be excluded from these requirements, including public companies not listed on a national securities exchange, emerging growth companies, smaller reporting companies, majority-controlled companies, and others with different board appointment provisions. Our proposed legislation also makes it clear that the failure of a public company to comply does not affect the validity of any corporate actions, and that nothing in this provision would alter the general standards for any director of a public company. The working group, which included the senator who proposed the earlier version, has been supportive of our approach. Members of CARC have also reached out to various potentially interested stakeholders to request feedback on our proposed provision. For instance, the LLC Partnership Committee and the Litigation Committee of the WSBA have each responded with a neutral provision. The Association of Washington Business also responded with a neutral position. We also engaged in extensive discussions with an organization called 2020 Women on Boards, which has organized a national campaign dedicated to increasing the percentage of women on corporate boards. Their goal is 20% by 2020. They have also expressed support for our proposal. Finally, members of CARC have met on multiple occasions with members of the Washington State Women's Commission, a commission comprised of 13 members, 9 of which are voting commissioners appointed by the governor with the advice and consent of the Senate. The commissioners who met with CARC to discuss the proposed provision, including the director of the commission, provided their input and expressed support for our approach. So I'll stop there. I look forward to answering any questions you may have and engaging with you further on this. Thank you.
Thank you. And just to add a little bit more, the presentation before the Legislative Review Committee was robust. The Legislative Review Committee is charged with vetting and ensuring that legislation prior to going to the legislature is properly vetted and discussed with other groups, and they felt satisfied by majority vote that that happened. And they also voted on GR 12.2 in the affirmative. And so with that, I'll open it up to questions. Governor Swegill.
Good morning. Thank you for being here. So I'm the immediate past chair of the Corporate Counsel section, have been very involved with that section for 20 plus years. I'm also a member of the Business Law section. I don't recall, and I could be mistaken, but I don't recall that the Corporate Counsel section was consulted or has seen this proposal. Am I wrong?
I have to confess that I wasn't in the direct loop on seeking stakeholder feedback, and so I think what we know is what Diane reported. Mike Hutchings might be able to, the current chair of the committee might be able to shed more light on that, but no, I don't know that we did.
Do you know?
I don't. I'm not sure.
And I suspect also similarly that the Business Law section was not consulted?
Oh, yeah.
Or were they?
Yes, I actually made the presentation to the executive committee. Our process is, at some point, stakeholder feedback, whether it's before or after section approval. But the business law section executive committee received a similar presentation to this one and approved.
Did they vote on it? They approved it?
Yes.
And does the proposal, and I apologize, I didn't have as much time to review it as I would have liked to have. Does the proposal apply to just corporations, Washington corporations that are essentially, Washington, not Delaware? They're not foreign corporations, but they're Washington public corporations?
Yes, it's limited to businesses that are incorporated under Washington law, and not businesses that are incorporated under another state's laws.
And that's publicly traded Washington
yes,
corporations?
It's publicly traded companies. In fact, not all public companies, but only, there is a technical definition.
So you had emerging growth companies carved out. I think that is a very, 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 very small list of corporations, isn't it? It's very few corporations go public as Washington corporations for a variety of reasons. The vast majority are Delaware corporations, if I'm not mistaken.
And I think that's probably right, yes. I'm not sure what the number is. Is it something like
there's
50?
Microsoft, there's
I think there
Starbucks.
May be 50 on the order of less than 100, but probably around 50 public companies that meet the definition of this statute. the ones that are the most visible and the largest, and who are, in a position to have large enough boards
Right.
where this proposal makes sense, and who have been mature public companies where they've had plenty of time to be able to incorporate this kind of a new burden into their. And most of them, frankly, we looked, and most of them already meet the gender diversity proposals. I literally think there are, like, on one hand, you can count the number of these large companies which will have to explain what they're doing to get to the threshold that's been set.
Right. And from your description, it seemed like a fairly innocuous proposal, but, as someone who sets up corporations almost on a weekly basis, I'm general counsel of 4 companies, and I advise probably 15 others on a very regular basis, and, I'm involved in constantly setting up new corporations. The question always comes up, do you want to be a Washington corporation or do you want to be a Delaware corporation? And I go through a list of reasons for both. And one reason for being a Washington corporation is, as a Washington lawyer, I'm a little more suited to advising on Washington law. But that said, I also have to, be ready to explain the pros and cons of Delaware corporate law. To help people make this decision. The reason that most companies incorporate in Delaware at this point has largely to do with the concerns of investors. Venture capital firms will not invest in a corporation that is not a Delaware corporation by and large because their attorneys say, I don't know anything but Delaware law. California, as an example of someone who's adopted a law like this, is one of the states that everyone says, whatever you do, whatever decision you make, do not incorporate in California for a variety of reasons. And this will be potentially added to that list of reasons. I'm sure it is now added to that list of reasons that you'll just have to re-domicile when you go public. So to your concern that this, do we want more Washington corporations, companies incorporated in Washington? I'm not sure it really matters all that much. Maybe it's a point of pride, and it's Washington lawyers who want to be able to say, I work with a lot of companies and we incorporate them here. It's a bit of a point of pride. It does save a little bit of money to incorporate in Washington because you don't have to pay Delaware franchise taxes. You don't have to register in Delaware and then, qualify to do business and have a business license separately in Washington and pay double taxes. The other thing about registering in Delaware is you're subject to suit in Delaware, and you end up paying local counsel here and then local counsel there, and then your usual litigation counsel here. So there are some reasons for incorporating in Washington, and maybe about half the time I prevail on those reasons that you're not double taxed and you don't subject yourself to litigation in Delaware when our hourly rates are $800 to $1,000 an hour. But I think this would potentially just be one more little, maybe it's even a feather on that balance, but that balance is already well tipped in favor of Delaware. So one, I guess I would ask, I would suggest that I think the corporate counsel section should probably have some opportunity to review this before we vote on it. It's nice to hear that the business law section did, and they tend to look more at legislation than we do in the corporate counsel section. But I would be a little bit ambivalent about supporting anything that tips the balance further in favor of Delaware.
Well, if I can
Please
express give you my 2 cents on that, and I'm sure Diane has views as well. But as a practicing lawyer who's been in your position in terms of organizing many businesses into corporations over the years, it is, as I said earlier, one of our main goals to create as level a playing field as possible for Washington businesses so that when they make the decision where to incorporate, we haven't done things to the statute that will tip the balance in favor of Delaware. One of the reasons we're a Model Act state is because we don't have, and I would say that one of the reasons people incorporate in Delaware, or the investors are putting pressure on them to incorporate in Delaware, is because there is a much more highly developed body of common law in Delaware, because it's a vicious cycle. Once people start incorporating them in a place, then there are more and more of them there, and then that creates more and more litigation. Then you've got more and more case law. We don't have many corporate law cases annually in Washington interpreting RCW 23B, but we do have a model act. And so we have 30 other states who have done the same thing we've done, and that has helped tip the balance somewhat back into our favor. And certainly with regard to this particular proposal, it was a concern of ours. Delaware hasn't yet, and I emphasize yet because we've frequently done things and then Delaware follows a couple of years later, and often vice versa. Delaware doesn't have a gender diversity statute, board representation statute. But what we did, and I agree with you about California, and I wouldn't advise a client to do that. And had we adopted or recommended a statute like originally was presented to us by the legislative committee that covered all Washington corporations, including privately held businesses and all public companies, that would have been a problem as well. What we have, I think, is maybe the feather is right, but I think it's maybe even less than a feather, because I can't imagine counseling a client, a startup that's with the 4 or 5 or 2 organizers, or the venture capital to be venture capital financed startup, that this is a significant or material factor, because it's only going to apply to a mature public company, which is years and years down the road, by which time it's likely that that board will have adopted some policies with regard to how it's going to have a diverse board anyway. And as I say, almost all of the public companies to which this applies already have gender diverse boards by our definition. And so I would say that, and if it really is a problem for a public company, which again I think shareholders and shareholder organizations will put pressure on those boards in 5 or 10 years when they may be lucky enough to reach that stage, to insist that the board have diversity anyway. I think that if they really dislike it, they can reincorporate. And again, that isn't that huge of a deal either. We want to have a statute that discourages Washington businesses that have become successful public companies not to reincorporate. But I think it's a decision that would be way, way down the road. So again, I'm not too concerned about it.
Well, thank you both very much for your time.
Thank you.
I saw Carla first, and then Sunita.
I'm pretty concerned about this proposal. Obviously, you can see I'm a female. Obviously, one may infer that I'm very much in favor of women having an equal position with men everywhere, and quite frankly, I would submit that we basically have come a very long way since I first became a lawyer 40 years ago. So I'm concerned about this proposal, though, for various reasons. One is, it feels to me like you're trying to social engineer. And that isn't the purpose of GR 12.2. And Kyle, I have to say, if your committee said this was okay, I am stunned. Because 12.2C says the activities that are not authorized are taking positions on political or social issues which do not relate to or affect the practice of law or the administration of justice. This feels exactly like that's what we're trying to do. Secondly, I do want to point out, and you probably know this already, but for my colleagues, I want to point out that just a quick research here a moment ago, according to some information about Fortune 500 companies, there's a record number of Fortune 500 companies who have women CEOs this year. There are 33 this year, up from 24 last year. That's still not enough, I would submit, but at the same time, it's growing, and it's growing relatively quickly. Going from 24 to 33 is a pretty good jump in percentages. But more interestingly, and apropos to our discussion, 15 years ago, 15.7% of the board seats were held by women. This year, 25.5% of board seats are held by women. So 1 out of 4 1 out of 4 board seats are held by a woman in Fortune 500 companies. I find that significant, and I find it really interesting and useful information. Finally, I think, Mr. Reed, you said that this measure would be limited to publicly traded Washington companies who were incorporated here, and there's less than 100 of them, and most already meet the gender diversity requirement that this proposes. So then I suggest, why are we doing this? If most already meet that, for those few that don't, we're going to legislate everyone to do it, with the potentially chilling effect that the Governor Swiggles indicated, and my law partner does a lot of incorporations and gives the same advice to his potential incorporators that Governor Swiggle indicated. So I've heard this before, though I don't do much of it myself. I have to say, why are we doing this? And I know, so I get back to why we're doing it. It's social engineering. We're trying to force a quicker change than society is going to do. But society's already shifted. You know, we have statistics that show. We have a lot of women sitting on this board. We have a lot of women who are attorneys now who weren't 40 years ago. I could go on and on. But the main point that I'm making is that I think that this is a sledgehammer when we don't need it. So I'm not at all in favor of this legislation at this present time. Thank you.
Would the presenters like to respond to anything that
Sure.
Governor Henderson said?
Well, I mean, there's certainly room to disagree. I would say that we have precedent for, I wouldn't say social engineering, but for dealing with proposals similar to this in the last couple of years, maybe 5 years ago, and it arose out of the same sort of movement, if you will. Remember my opening remarks when I talked about how jealously we guard 23B. And if we see somebody coming in potentially with a sledgehammer, with some proposal, we do our best to protect the act. And this is partly, this may be in part response to why are we doing this. We are doing this because it was clear it was going to be done in this legislature. And the proposal that we were given to look at a year ago would have done, I think, serious harm to the practice of law in Washington and the administration of justice in Washington. And in particular, recall it's a mandatory, so talk about a sledgehammer, it was going to mandate that by a certain time boards have this certain level of representation on the board, women's representation on the board, and that if they failed to do so by that date, they would pay a penalty. So that essentially would put lawyers in Washington advising Washington businesses in a very difficult position in terms of how to counsel a client about what's the validity of a corporate action that's taken by the board if you don't meet that requirement. And the Secretary of State expressed concern because it wasn't in a position to enforce the penalty provision. And it would cost, it said, $1 million or more dollars in retrofitting of its system in order to be able to be in a position to do that kind of enforcing. And so in particular, in response to that, a couple of the provisions that Diane summarized, I think, are important. We're intended to address that. One, this is, while it is a requirement, the penalty, if you will, for failing to meet the requirement is that you explain to your shareholders what you're doing about diversity generally. And by the way, we broadened that explanation, so it's not just what are you doing about gender diversity, but it's what are you doing about diversity generally. We thought it was, at that stage, inappropriate for a board only to have to talk about why we don't have enough women. They should talk about, all of the diverse groups as they're defined in the statute, or people who are historically underrepresented on boards. But we also said that if you failed to explain, as you're required to do in the statute, then the corporate acts that are taken in the meantime are not invalid. I mean, this is so important to the corporate practice, to the transactional practice, that when a lawyer has to give a legal opinion, which Diane's going to be talking about again when she addresses you later today, when you have to give a legal opinion that something is enforceable or that an act is valid, that's been taken, that's fundamental to the transaction being legal, if you don't know, if you haven't complied with this provision, that would be a horrible result. And so again, to protect Washington corporate practitioners who practice transactional and corporate law, we have a provision that we're proposing as part of this that say failure to comply is not going to hurt you that much, because all you have to do, I mean, your corporate acts that you've approved in the meantime are still good. And secondly, as to administration of justice, it also tells a court what it does if somebody complains. There's a particular provision that says if you go to court and allege failure to comply, the court's remedy or the complainant's remedy that the court can issue is an order to comply within a certain period of time, that is, with the explanation. So again, I think that those are pretty compelling. If maybe it's true that in a perfect world where we weren't faced with a statute that was likely to be passed anyway, we could have ignored this. But we felt, as we did, I alluded to a few years ago, with social purpose corporations, where we had the same debate in the Corporate Act Revision Committee about, well, should we really be coming up with a new entity that's a corporation plus that has the right to have as its mission not just maximizing corporate profits, which is the historical provision, but also reason for business corporations, but also to have other goals like the environment or the employees, employee democracy, or other such missions. And we wouldn't have done that but for the fact that there was going to be a statute, a comprehensive statute called benefit corporations that was going to be dropped, that the legislature was likely to pass, that was a much more prescriptive, mandatory, and difficult statute which did not at all mesh well with 23B. So we took on the task then of coming up with a new chapter to 23B that wasn't entirely separate, ignoring it, and that meshed well and also met the enabling purpose of the Act, as opposed to saying if you choose to be social purpose, you can do the following things, but you don't have to do them, which is what the other statute from this Philadelphia group was going to do. So, I think that's the reason that we think that this is very much related to the day-to-day practice of Washington law by Washington practitioners, and it gives them the ability to give specific, explicit advice to them about what the law is and what happens if they don't comply. It's easy to comply, and the courts know what to do if somebody complains. So that's my explanation.
Thank you. Governor Hunjaval.
Thank you. My concern with this proposed legislation is regarding the enforceability of. To me, it seems aspirational. You're saying to your companies, you need to have 25% women, but if you don't, you just need to explain. And then what? What does that mean? Is it a term of art, board diversity discussion and analysis?
Well, I think that we assume as corporate and securities lawyers that representing public companies that when we have to explain something to our shareholders, particularly with these institutional shareholder groups like Institutional Shareholder Services, which is, on a daily basis pushing corporate managements around the country to do things that favor shareholders in terms of the great balance of power between management and shareholders, that's a meaningful and there are other more progressive groups that are doing the same thing by buying shares in a corporation, and then that gives them a right to speak, at shareholder meetings or through shareholder proposals. So I think the answer is that maybe it isn't going to do much, but I think that you don't give credit to the impact of having to explain why you've chosen not to adopt a diversity policy, and why you haven't considered provisions. One of the other things I'm not sure we mentioned, but there's a provision that says you have to address methods of refreshing the board, either by term limits or other means, so to provide an opportunity for there to be vacancies so that you can fill them with gender diverse folks or with diverse people. So I think that those are all meaningful provisions that I would say if I were a lawyer advising some of my clients and said, well, you don't meet the requirement, but unless they actually said, well, we don't agree that women should be serving on boards to that extent, I think what they're going to do is they're going to actually say, well, let's adopt a policy and let's follow it. And I think that it may have more meaning than you think. But again, the problems with being any more prescriptive than that are the ones that we were discussing earlier, which is that you're taking a sledgehammer and you're putting people in a position where, one, the Secretary of State's office won't be able to enforce it, and people won't know whether the acts that have been taken while they're not in compliance are valid or not. So we think this is a good balance. Maybe there are others, but I mean, we've spent a year thinking about it, and this is the best we could come up with, and it's consistent with other situations that we have, like social purpose corporations, and we have the same remedies in that statute about if you don't comply, then you can go to court, and the court will compel you to comply. That is, to provide the annual report that explains how you worked towards meeting your social purpose that you've stated in your articles.
I also think that having that discussion and analysis, it creates a buzz, and I think a meaningful buzz and discourse about diversity generally, and that's a goal that's shared among everyone in the corporate space. And then also that 25%, ideally in a few years that becomes too low of a threshold, and then it's easy to amend and raise it up so that we're always moving forward.
Thank you. Under presidential privilege, our president would like to go next, and then Governor Kang.
I love it. I mean, I love it in the sense that I hate it, because I'm probably one of those people who wishes it was more robust and stronger, forceful legislation. But I think that if you guys looked at this legislation, and I think I'm going to be less polite than you are, I think you guys are being very polite. You've seen some bad legislation. It's going to pass. It's coming down the pipeline. And you've taken some steps. You've looked at it. This is what I'm hearing from you. You've looked at it. You say, this is trouble for lawyers. This is trouble for the administration of justice. This is trouble for shareholders, corporations, the practice of law in our state. And you have crafted a remedy, a compromise, which I'm a big fan of compromises, even though the compromise is not necessarily going in the direction I want. I think you've looked at this and said, here's how we can fix the problem. Here's how we can avoid legal problems. Here's how we can get shareholders more information. Here's how we can make this constitutional. And you've come up with a solution. You've put a lot of time and effort into it. You've been coming to business law section. I just want to say thank you on behalf of the Bar Association for all the work you've put into this and coming back again on Saturday morning, because this is important to you. Obviously, you took time out of your weekend and got rescheduled to here. But thank you for your work on this, and thank you for trying to help us find a way to make the state and the service of lawyers to its public the best possible. Thank you.
You're welcome.
Governor Kang.
Thank you. I have a comment and then I have a question. My comment is I think it's great, and actually I wish we had something similar like that for law firms where partners there should be more women. So I certainly understand that. So I support the purpose and intent behind this. My question is, so I'm looking at your materials, and under the stakeholder response, for example, Secretary of State's office support, and then there's Washington State Women's Commission ongoing, 2020 Women on Boards ongoing. So what does ongoing mean? And I think Paul made a comment about how the corporate law section, they were not, you guys you're not sure if this was brought forward to that section for their thoughts and response. So is that something that you're planning to do, where you're planning to reach out to more stakeholders for their response? Does ongoing mean that they're still looking into this? Can you provide a little more information about that?
Well,
Sure would.
we're this is also secondhand, a secondhand report. So what Mike Hutchings told us is that he had met extensively with the two women's groups that are identified there, and that and had healthy ongoing had a healthy in-depth discussion, and at the end of the day they endorsed it. So I mean, I think both of these women's groups are in favor of this provision. That was my impression.
those groups have expressed support for this approach.
And I believe we had the same discussion at the Legislative Review Committee, and my recollection is it was properly vetted. Sorry. My recollection at the Legislative Review Committee was that we did ensure that several of the women's group were consulted with, and at least they were satisfied that proper vetting was had. Let's finish with the questions first, and then we'll get to Sanjay too. Governor Tollefson.
It's a two-part question. So you talked in your materials about the January 2019, a group of Washington senators proposed legislation. So where is that, their proposed legislation? Is it still in the hopper? Let's put it that way. Number one, it's a two-part question. Okay. I'm going to let you answer them both all at once. I'm going to let you answer them both all at once, so I don't have to, jump on the mic again. Will this proposed legislation of yours stir up that legislation, which clearly, from your point of view, is less favorable?
So the answer is that we have been working closely with the original drafts people and sponsors of the what I will call the rogue bill. Don't quote me. The other bill, and they are supportive also. All of them are supportive of this bill, and maybe this is a time for me to emphasize or to explain our great relationship with, in particular, Senator Peterson, who has been our advocate, our standard bearer in the legislature for ever since he's been there, and he's working with this group as well. And he's made it clear that no bill is going to get through on this subject is going to get through his committee, which is the Senate Judiciary Committee, the key committee, without CARC having signed off on it. And CARC signing off on it requires you to sign off on it. So we really have built a firewall. And I will say that, with regard to important corporate legislation, we have such wonderful stock given to us by the legislature, largely again through Jamie Peterson having been our cheerleader, that I feel like we've fended this one off. And we also fended off the rogue bill with respect to benefit corporations when we were doing the social purpose corporations, where he said the same thing to this group from Pennsylvania, that, you're not getting your bill, we're going to do the Bar Association's bill. And I'll also say that, we have to be very careful with how we use this power, but a bar bill is gold, at least in my experience, or a corporate bar bill in any event is fairly golden. And the number of times I've testified before the legislature, I have a leg up just because I'm testifying on behalf of the Corporate Activision Committee of the Washington State Bar Association. So you guys have done a great job building a reputation, and I think we've done a good job at guarding it so that we're not stirring things up in areas that are likely to generate hostile responses and like you're overstepping your bounds. But I appreciate your concerns, believe me.
Thank you. Governor Stevens.
So I have a comment and then a question. But a part of my comment is I think it would be of value to continue to reach out to other areas and sections that actually ordinarily should have been and close that loop. We absolutely will do that. I mean, it's on my list. And if it wouldn't be rude for me to send an email right now to Mike Hutchings, I would. But I'll definitely get back to you with the answer to the question. And if we haven't done it, we'll do it. Okay. And if I understood, yes, I do. Did the rest of you hear me? But I'll make sure you hear me, Governor Hunter. Thank you. We're having fun. But as I understand this, and especially your last comment regarding Senator Peterson, I'm not getting a sense that we have to act today, but we could act in January.
In my experience, that's not, I'll let the legislative.
Yeah, it is set for action today, and part of the reason for that is so that CARC can move forward with what they need to do to try to get it passed in the legislature. Now, of course, you know, if the Board of Governors is inclined to vote it down and needs more time, you know, that's something we should consider.
Okay, well, but I wonder how that works if, for example, major sections, at least there's a question about vetting, and so I'm just going to leave that there.
Okay, thank you.
But there's another area that I just wanted to talk to my fellow governors about and council, because you actually give the great example of what is our work to be, and I'm talking about as an association, when an issue is coming before the legislature that could have a very serious impact. And because the issue has in it, quote, a political bent, we do nothing because it's political, but it's actually legislation to change the law and change how we approach the law. And so I think about your example where there was what you call the rogue bill, and
there you go, quoting me again.
The quote,
I'm kidding. Yeah,
rogue
I'm kidding.
bill, unquote. But you saw that there would be a problem if you did nothing. And this then just went through, and then we, you, maybe corporate counsel section, others, are now trying to deal with the aftermath because we shackled ourselves because of the, quote, political or social nature of the legislation, but it was legislation that was going to change the state of the law and change how we then go forward with our practice.
Correct. You've hit it right on the head.
But I just want to make sure that even when we're looking at GR12, we're not looking at it from the standpoint of, oh, because of the subject matter, we're going to ignore that this is going to change. So, for example, if somebody said, oh, I want to amend the Washington law against discrimination, and yeah, I know you passed sexual orientation before, but we now want to take it out, I would be, certainly I think folks in my section, civil rights, would be apoplectic if the answer was, well, we could do nothing. But we're about to take out an entire category that had been fought for. So I want to make sure we understand what our role needs to be and not turn on controversy, but what the impact is to the practice of law and the administration of justice, regardless of what the issue might be. Because otherwise we can find ourselves in this position where there had been a lot of support before, and now we are stuck not being able to act because someone says it is political or social. Thanks.
Thank you. Our Outreach and Legislative Affairs Manager, Sanjay Walvikar, is on the line. Why don't we recognize him? I understand he has some information to share to answer some of the questions.
Thanks, Kyle. I don't actually have any new information. I was just earlier reiterating what you said about Mike Hutchings reaching out to some of the women's groups and affirming what you told the board, that they were in support of this legislation.
Great, thank you. Governor McBride.
Thank you. And thank you both for coming and presenting. I value what Paul said, his expertise. It's not an area of my practice, and so I appreciate hearing that. And I think Governor Higginson raises a good point about GR12 that's valid in this arena. But I'm a big fan of workable compromises, and comply and explain to me is preferable to penalties. And I feel like that's kind of the issue in front of us. So I don't think there's going to be a big problem that's going to arise, but there's still two different sections of the legislature that are going to look at amending these bills if something does come up. So I'm hopeful that we vote to support them today, and I appreciate the work you've done on them.
Thank you.
I have Governor Abel and then Governor Higginson.
Good morning. A comment and then a question. First of all, the comment. Like everyone, I want to thank you for being in here today. I appreciate it. Both the comments on the gender diversity, but then also the brief comments in the materials regarding the non-substantive revisions of 23B. That's unsung work, and
wow.
We really appreciate it. So thank you. My question is really more for Kyle. The committee's already taken a look at 12.2. I'd be really interested in just a brief summary of the discussion about 12.2, why it was decided that this satisfies the rule. Thank you.
Historically, from my perspective, the Legislative Review Committee has taken a much broader view of 12.2 than the legislative or the Board of Governors Legislative Committee. They often do so without legal advice concerning 12.2. It wasn't a unanimous vote, but it was by majority, and so there was discussion about whether it had satisfied that, and at least one person thought that it didn't. But I couldn't speculate as to the other 8 members of that committee, how they reasoned through that. My assessment is much like Governor Stevens said, is that this is well, there might be 2 perspectives to this. One, the administration of justice and diversity and inclusion for many folks is part of access to justice and not a political or ideological issue. And then also, if you delved in a little deeper into, not only the words in 12.2, but also information from the Keller decision and other cases, efforts to improve the law is also something that people have thought should go into whether it satisfies that rule. That's a little farther down than I'm comfortable with, but I do think, in my own personal opinion, that including this in diversity, inclusion, and access to justice is affecting the practice of law.
Thank you.
Thank you. I guess I would say, first of all, that I believe anything we do here with regard to this bill or this proposal and anything else, we really need to look at it through the Keller deduction lens. We are not out of the woods yet on that matter. And it seems to me that when we're talking about social engineering, which I submit, as I said before, we are, that may well be further along the continuum of what Keller prohibits than I'm very comfortable with on behalf of the Bar Association. I also would simply like to say that I think almost all laws affect the practice of law. So I'm not really compelled by the idea that this will affect the practitioners. I recognize it will, but so do almost all the laws that the legislature passes. We all have to, in our various practices, and read them, understand them, interpret them, and advise our clients accordingly. So that should not, to me, be the compelling reason that we act on this bill. I also would just like to note that if we'd had a better legislative presence last year, we probably would have known about this other bill and might have been able to send it out to the sections, and our legislative committee might have been able to weigh in on it. But I didn't actually know about it until you told me about it today. So I'm also troubled by that, but that goes back to our discussion of yesterday about why we need a better legislative presence and more intel on what's coming down the pike so we can grab people like you guys and say, help, what are we doing here? So all I'll say in conclusion is that I still ultimately, with respect to my fellow governors, And I certainly agree with Governor McBride that compromise is better than having something happen that is not to our liking. And so I'm mindful of that. But with the comments that have been made about the feeling of the Senate Judiciary Committee chair at this point in time, I don't feel like we have to choose to do this today versus waiting and having something bad happen. I don't know that it's an administration of justice issue any more than any other bill is, and I don't know that it's an access to justice issue, which I understand access to justice means access to an attorney to help you get through the legal system and have your matter heard. I can't possibly fathom how this could fall into that category. So those are my final comments, and thank you for the chance to speak again.
Thank you. I'm mindful that we've spent now an hour on this part, and we're going to need to get to the second bill here quickly. So, Governor Hunter.
I just have a quick point. Thank you again for being here. Even though I'm not in favor of this, partly because, first of all, Mr. President, Mr. Now President, I believe everything is either social or political. I mean, in this day and age, just can't get away from it. And I'm in a little bit different area of law because I see diversity a lot, but the diversity that I see is not necessarily a good thing because I'm a criminal defense lawyer, and there's a tremendous disparity in the number of clients that I have who are largely unrepresented populations. So I see it on the flip side. The thing that I'm uncomfortable with this is I think my fellow governors know, I don't like anything that says you must or that's mandated. So for that reason, I'm not comfortable with this. Maybe I need a little more reading on it. But as of right now, I can't support it with the way it's reading right now. Thank you.
All right. I think I've covered everyone. Part of the sentiment that I've heard is that perhaps we should be including other groups. Maybe we need more time. If that's part of the factoring going into our vote today, and the vote would be no because we haven't had more time, I would entertain a motion to have this go to the Board of Governors Legislative Committee first before we take ultimate action. If we feel that we have had enough time, then of course we should entertain a motion to proceed forward.
I would move that we direct this proposal to the legislative committee that you chair for the Board of Governors for further consideration.
Second.
Second.
I'd second that.
All right. Any discussion on that? No. All right. Now let's go ahead and vote. All in favor, say aye.
Aye.
Opposed? Abstain? Okay, that carries. So we will schedule a legislative BOG meeting relatively quickly and have that discussion there. Hopefully you'll be available. We'll work with you to make sure that you're available to present to that committee. And then once we've gotten through that process, then we'll figure out what we need to do to bring it back to the full board. Okay, thank you. And then let's, the next bill, let's get into that. And if you can give us another quick background and the description, that would be helpful.
Sure. This is, I hope, less controversial. This is really, this part of the bill is part of our ongoing kind of methodical review of the existing revised Model Business Corporation Act, which is overseen by the Committee on Corporate Laws at the ABA level. And it came out with a complete, I think I mentioned earlier, an entire almost new revised act in 2016. And we are going methodically through each chapter and deciding, is this really an improvement to our Model Act? and bearing in mind that each time we stray from the Model Act, then it's harder for us to call ourselves a Model Act state, but we're nonetheless going through each provision, and this is, at the beginning, it's Chapter 2. We had already made a couple of changes to Chapter 2, RCW 23B.02, in prior legislative sessions that reflect the 2016 version. And this is essentially wrapping up Chapter 2, at least the first part of this tripartite group of changes. And it's essentially, I would say the principal change to this section is and it's about what you have to include in your articles of incorporation when forming a corporation. Before we had kind of an encyclopedic section that not only listed the mandatory provisions, which are there are 4 things you have to do to put in the articles in order to comply with the law, but there are 6 pages, statutory, codified pages that say, well, here are all the things you could do if you wanted to, and then there are cross-references to other chapters in RCW 23B. We decided that was redundant, probably not helpful to most practitioners, and you kind of have to wade through all of that in order to distill what do you really have to do. So we are proposing deleting all of those optional provisions and instead dropping them into the commentary. And, we don't have legislative history, unfortunately, at the legislature anymore. But what we do, we have, this is a little plug for the RCW 23B source book that we published in 2005, and we're doing our best to keep updated, where we have the entire legislative history of each section of 23B, and it includes the Corporate Act Revision Committee commentary. So we're proposing moving all that into commentary so it's a much shorter statute and it's consistent with the current Model Act. So that's kind of the big change. And we're doing the same thing with 23B 02060, which deals with bylaws, which also had a whole bunch of optional things you can include in bylaws. We're now deleting all of that, and we're simply dropping it into our source book commentary. And now a practitioner can look and see simply what do I need to put in articles and bylaws in order to be in compliance with Washington law. So that's the first set of changes. There are other more technical changes and additions of a definition or two that I'm not going to, unless somebody wants, I'm not going to explain, but I hope that the cover memo, explains adequately what those provisions are. The second area for the proposed amendment in this more technical section is a proposed change to 23B 07210. Again, this is what we think is mostly a clarification, and it deals with confirming the concept that a corporation cannot vote its own shares, that is, shares that are in its treasury or that are authorized but unissued shares, in connection with shareholder voting. That's a way to assure that there's not perpetuation of management, which you could easily do by having a bunch of unissued shares that you vote. The reason we think it's an important change is because there is a section on the books, 07210, which says a shareholder can't vote shares that a subsidiary owns of it. So this would be where instead of holding the shares, the parent company issues its own shares to a subsidiary, and then the subsidiary circularly votes the shares to perpetuate management of the parent. And that is flatly and explicitly and always has been prohibited. But interestingly enough, there's nowhere in the statute that confirms the even more obvious tenet to avoid perpetuation of management, and that is that you can't vote your own shares. So that's all we're proposing to do with that. It may look like more when you read the statute, but it's not. The third area of proposed changes deals with an amendment to 23B 07040, which deals with actions by shareholders in lieu of a meeting by written consent. It's on the books now, and it's a Model Act provision for the most part. But the one thing that we don't have is that, a couple of things. We have our provision applies only to privately held corporations. So shareholders can act by unanimous written consent, or if the articles so provide, can actually act by a simple majority by written consent, but only if you're a private company. Public companies can't. And the Model Act provision provides for that. We don't really see any good reason not to permit public companies to act by consent. It's probably not going to happen that much on widely held companies because you've got to circulate and get the consents of either all the shareholders, which is not ever going to probably be likely, or a majority of the shareholders if the company has so provided in its articles. And so we're proposing that change, which would, again, cause us to be consistent with not only the Model Act, but most of the, if not all of the other Model Act states who have this provision. And then there's another technical change. The Model Act makes it clear that you can't act by less than unanimous consent, written consent, when you're dealing, if you're a company that has cumulative voting with regard to the election of directors. Again, that's a technical point. We'd never said you couldn't do that. I'd challenge a corporate lawyer to try to figure out how to do it by written consent because cumulative voting, requires applications of a kind of complicated formula, and you can distribute your votes, and I don't know how it would work. But we're, again, going along with the Model Act and conforming to it and not permitting actions by written consent where you're dealing with a cumulative voting situation. I think those are the highlights. There are many details, and I invite you to either ask me about big picture issues or details.
Thank you. Open it up to questions. Governor Swegill.
So focusing on the provision that would provide for less than unanimous written consent, can you compare and contrast that for the group relative to Delaware law and the pros and cons?
I can. Delaware law permits acting by less than unanimous written consent of public companies and private companies. The interesting thing about Delaware law, and we started this process, this shows you how our legislative process works. There were some of us on the committee, I wasn't one of them, but some of us on the committee who wanted to change the presumption in the statute so that when you form a corporation, the default rule is that the shareholders can act by less than unanimous consent. That's the way Delaware is. Delaware, in order to make it unanimous consent, there has to be a provision in the Articles of Incorporation mandating it. The Model Act is like we are, where the presumption is a requirement of unanimity, which makes it a more practical rule for privately held companies because it's only in a closely held company that it's really practical to get everybody to sign off on a particular corporate action that requires shareholder consent. And we decided that we didn't want to, despite some pressure from members of the committee, I think, who think we'd be more, if we're more like Delaware, as you pointed out, will not lose Washington businesses to Delaware. But on balance, we concluded that this was not an example where we really wanted to stray from the Model Act. We didn't see any reason why it shouldn't be a conscious decision to permit less than unanimity in a situation where you're dispensing with a meeting and you're saying just sign here. And so we think that it should be that the Model Act drafters had the right idea, that it should be a conscious decision to permit majority voting by written consent. And so you should have to put it in your articles and get approval, either on formation or through amendment of the articles.
Governor Stevens.
So I was also looking at the stakeholders, and I was surprised that Governor Swegill didn't raise any question about this coming to your section, to corporate counsel.
I was making a presumption that it had not.
Okay. But I was really, so I'm really directing this more to Kevin Platchey and to Tara, because I'm reminded as from the Civil Rights Law section that at times there were actions that we were interested in as a section, but because of the action, we probably needed to have coordinated with other sections. And so I just want to kind of make sure and request that we do that and we do more of that, because what my experience is the various sections really come together twice a year, but when there are matters that we're working on, we probably really do need to just have a facilitated coordination with other sections' impact, so that we don't come to this point in front of the Board of Governors and have missed some other sections that at least we probably should have talked to. We may not have agreed, but at least there was we've touched base that everybody was aware that we were working on X item, and so we don't hear, well, we never heard of that at all. So I'm sorry, it's not so much a question for you, although it follows the whole idea of vetting and vetting other sections.
Yes, although I have to say that I was rude, and I did just send an email to Mike Hutchings, and maybe I'll get an answer before we walk out of here. But when I was the chair and was, I hope this doesn't reflect badly on where things have come, but it's my understanding that our lobbyist, and I worked with her, in connection with this, distributed the bill, if not to all sections, to many, many sections, and through their executive committees, and then we'd hear back no, neutral, no objection, no comment. So I don't know what's been happening now. Mike highlighted the sections that we circulated it to, and maybe things have changed. But this feedback I'll clearly carry back to him, and I'm sure Sanjay's on the line, and he'll take under advisement about how widely proposed legislative packages ought to be circulated. I mean, I have absolutely no trouble, and think people should say, well, we don't care about that, we're not going to look at it. But to know that they got it would be, I think, an easy thing to do, and so why not do it?
And I would mention that the primary purpose of the Legislative Review Committee is to ensure that vetting. And I'm not so sure that we once were larger and had a more broad perspective from practices from across the state. Now we're smaller. I don't know that we hit on everything, but we try to do a pretty good job of thinking of who might be out there that should hear about this and should be questioned as to their position. I'd be surprised if it didn't include the corporate law section itself, but I don't know that for sure. My recollection is I don't know if they did. So I'd wonder if Mr. Waldekar is still on the line, if he remembers or has the materials for the folks that were consulted with and vetted. Sanjay?
I do, and the corporate counsel section is not included.
Not included.
Correct.
Okay. Well, with that in mind, then, again, if not ideal, but if the Board of Governors thinks that we need to have more time to vet with that particular section, perhaps we could entertain a motion to do that. But before we do that, Governor Stevens.
Yeah, no, that's not my comment. So I'm actually suggesting that, it's nice that the Legislative Committee, it's a good thing for the Legislative Committee, but I was actually talking about sections staff and their role in helping us all do that, because they're in contact with the various sections just to make sure that that happens. And I recall that at times because in your own section you get going on what the legislative packages are that you want to focus on, not what we're reacting to, so that we can do our GR12 analysis, et cetera, but we get so wrapped up into that, we're not necessarily touching the other impacted sections, and I think section staff can help us do that. understanding that we also will need to kind of, again, train up and coach up the sections, that this is not about Central WSBA trying to manage or force their business, but it is about trying to help make sure that even that section, if it's rolling, isn't, quote, blindsided by another section saying, well, we never heard this. And so.
Director Nevitt.
Yeah, I just want to say I appreciate the suggestion, and I've noted it. I was actually, I actually got an email from Nancy during the meeting about how challenging it is when you only get the board book a week in advance to go do the research. And I was feeding back that, part of the challenge, I think, is that we can't rely on when the book comes out to then things going and being vetted. I think they have to be vetted in advance, and we really don't have a clear set of expectations around what that vetting looks like. And I was telling our president that the Board for Judicial Administration has a really interesting and written out procedure for how proposals come to them and what sort of steps they have to go through. And so I'm thinking about proposing something like that for the board, and I'd welcome anybody's input on what those necessary steps are.
Felix.
And to supplement what Tara was talking about, one of the other things we said we were going to start to do was have a kind of a unified calendaring system so that all the other governors know when the other meetings are. And part of what I think we might be doing is having some idea of what the agenda items look like respectively, so that you might have a better window into what everybody else is working on. It's a first step to what Governor Stevens was referring to, but it's partly a way that everyone will have more visibility so that we can coordinate and orchestrate in a little bit more orderly way.
All right. I see a couple folks in the audience. Before we do that, any other governors have any other questions? No? Okay. Nancy Hawkins?
I know we're going to be talking a little later about the section's direct involvement with legislative matters, and I think we will find that sections are more quick on their feet, more fluid, more able to make the kind of decisions to make comments on legislation than the Board of Governors is. Because the idea of deferring decisions on legislative issues to January, you might as well not have a legislative program at all. Decisions about legislation are made now. They're made in August. That's when legislators are lining up their draft bills. That's when they are getting ready. That's when they're strategizing. That's when they're, Mr. McBride was saying, it's gossip, it's trust. That's happening months ago, weeks ago. That's not happening in January. January is where tiny little tinkling of bills happen, little tweaks. But the ship has sailed if we wait until then. Sections, generally speaking, know when they look at a draft bill, okay, this is something we care about, but I see this little section, oh wait, that's a criminal component. Maybe we should get the criminal law section involved in that. You can trust, I think, that sections will try and point those things out. I don't think we need to add more to the sections staff. We have legislative people, and they're the ones now that should be helping direct bills to us, but also we direct bills to them. But we have to move away from this idea that the only thing we can do is, and that's what the legislative committees of the Board of Governors focuses on, is legislation we can support or propose. I think we had a prime example this morning of legislation that somebody else is proposing. And the question is, are we going to let it go and be bad? Or are we going to be able to make comments or suggestions? Even if all we do is say, here's an idea that someone has brought, here's a bill, and here's the effect it will have on victims of domestic violence. Here's the effect it will have on fathers. Here's the effect it will have on children. If all we're doing is commenting on the potential effect of a bill, we are at least doing something to try and have the decision makers make a better decision. But all of this talk is, how can we not do something? What are all the reasons we shouldn't take positions? What are all the reasons why we'll be in trouble for doing anything? Well, we have a legislative program. It is part of our purpose. We need to implement it fully. And we can't be afraid. We should be justifying what we do under GR12, not using GR12 as a reason for us not to do 100% of the things that we could be doing. Improving the legal system isn't just passing more money to have more judges. It's recognizing that litigants don't speak English sometimes, so we need interpreters. It's a whole range of ideas that we need to be part of solving and tweaking and bringing forth with bad bills. Bad bills can make good law if they get decent comments. So when we get to the bylaw change later, I hope everyone will keep that in mind. But going to these meetings month after month, how many times do hardworking people come, having studied something from every perspective, and with no disrespect to the people who commented on this topic, but invariably somebody says, "Oh, I didn't read it," or "I didn't know about it, so it better go somewhere else first," or "Gee, good things, but did you think about this?" And then these good people who volunteered, well, what was the point for volunteering? Because nothing I said got trusted. Nothing I said was really listened to. We are just encouraging our volunteers to flee the organization because nothing they do is given any credit. Civil rules, the work on this business bill. At some point, the Board of Governors has to say, once they have people doing work, okay, we're going to trust that they did that study, or at least get involved a little bit earlier in the game.
Thank you, Nancy. And I'm mindful now that we're going on an hour and a half, so let's wrap this up. Jean Cotton, did you have something to add?
And I'm really reluctant to speak now because I was going to keep the majority, and I will keep the majority of my comments when we get to the bylaws. But this is a perpetuation of the conversation we had yesterday about strengthening the lobbyist. That's really what this is. This isn't these folks' fault who have done a great deal of work and effort and should be proud of their work product. This is a function of what got broken over the last few years, of how the centralized authority was not allowed to send it out to the various sections for review. It's not these folks sitting here's job to do that. And so they do all their work and then they come here. And Nancy's absolutely right. If you delay until January to support or disapprove, you've missed the boat. You've absolutely missed the boat. It's unfortunate this didn't come before you in July, so that if there were tweaks that needed to be made or other groups that needed to be heard, it could have been heard in September or then now. But that's not these people's fault. They've done a good job. And because we're under the legislative committee stuff, again, I was going to wait until they were done, but I don't want to get back up and talk again. You've indicated in your materials that the Uniform Arbitration Act has been, pulled because it needs more work, and that's true. It's got problems. But there's something that's not on your list. Carla, Governor Higginson mentioned it yesterday from the elder law perspective. I'm going to mention it today from both elder law, family law, and juvenile law's position or idea, and that's the UGA. That wasn't addressed by this body. And we have got, I'm sorry, the prime sponsor we need to court, but we've got a horrible situation with a law that passed and now a 213-page amended bill with no time to review it. None. We got it 5 days before the hearings that were yesterday and Thursday, work group meetings. That's not okay. And whether or not WSBA strengthens its lobbying efforts, and whether or not you pass your bylaw amendments to give back to the sections what they dearly need and deserve, their ability to testify. It's a bigger question here. I noticed in these lovely people's material, one of the stakeholders they went out to, the Washington Association for Justice. I still call them WSLA. It's those other private entities we need to be communicating with as a bar. The minority bars, they're not under the sections. Draw, we're not under you, but we're lawyers, we have common goals, and we should all be talking. So that's all. I think this is a systemic example of the problem that was created over the last couple of years that could have been avoided with a stronger legislative presence and support. This isn't dissing Sanjay in any way. He's been working valiantly. But it's also the reduction of your legislative committee that took the experts away.
All right. Thank you, Gene. All right. With that, let's bring this to a conclusion. I'd entertain a motion from the board.
Do that. This shouldn't take long, but I should have made the same point. That is Ms. Hawkins. I don't know you, but that she made eloquently about the timing. And I assumed that if you said in short order you delegate this to the legislative committee, and I assumed that would mean that if you were satisfied with the outcome, that we'd get approval, in short order as opposed to January. She's absolutely right. January, this isn't happening. There won't be a bar-sponsored bill on this subject if we don't get approval in short order, as you said.
And so I was envisioning that for the first bill that we talked about, but Governor Stevens' questions about further vetting corrected my misunderstanding. So I would like to entertain a bill or a motion to approve the proposal at this time.
So move.
All right. Any discussion? All in favor?
Aye.
Aye. Opposed? Any abstentions? 2 abstentions. All right. So we've approved it, and so for that one, the other one will have to go back into our Board of Governors Legislative Committee. There's a possibility that we could still have that discussion if it's and if we get through that committee, there's still a possibility we could have a special meeting for the Board of Governors to move that forward in December. But it'll be subject to the Board of Governors Legislative Committee. All right.
Thank you so much for coming. Being here and making the time to address the Board of Governors. Next we have legislative priorities. Governor Shikhedi and hopefully Staffer Wavakar are still here, and this includes ABA matters probably, but what's happening, Governor Kyle? Governor Shikhedi?
So do we still have Sanjay on the line?
I'm on the line. I just want to let you know I have to jump off here in just the next few minutes, but I'm on the line for now.
Okay, and so can you walk through the legislative priorities and how we arrived at those?
Sure. I really don't have much to add that's not already contained in the memo to the board. But a couple points I'd like to reiterate. These are long-standing priorities. They're drawn directly from the WSBA guiding principles and GR 12, which obviously outlines how we're allowed to participate in the legislative process. I encourage you to approve them.
Okay. Any questions about the legislative priorities that you can find in your materials? Not seeing any. I entertain a motion to approve the legislative priorities.
So move.
Any second? Great.
Right. All in favor?
Aye.
Any opposed? Any abstentions? 2 abstentions. You want those recorded? All right. Motion approved. Thank you.
All right, Kyle, let me I'm going to run this. Did you want to talk about, was that ABA part of that or anything? No? All right. Next, we're going to have Legislative Review Committee recommendations. Is there any public member comment on that? Comments will be limited to 3 minutes on that matter. Seeing no public comment, Governor Kyle, do you have any comments on the matter? Thought we did legislative priorities.
No, we've done them both.
Great. We're done. Good work.